undergraduate degree in business administration, and 2 years later he went on to get his law degree from the same school. He, like myself, went to Duke University to get the certificate in nonprofit management, 2004. That's where I remember you from.
Okay.
And he was honored by the city of Raleigh in 2011 with their Human Relations Business Award. Jeff speaks a lot. He conducts lots of seminars. He and his wife Kathy live here in Raleigh, and they contribute a lot to the community, but his specialization is in estate planning and life planning. He's also the author of several books, including The Anti-Probe Revolution, The IRA Trust, and other life and estate planning books that can be found on Amazon.com. Jeff is going to speak to us on a topic today that we increasingly run into. It'll also be addressed at our state conference next month, and that is the increasing need around our LGBT community. I know that Monica's doing a lot of work around the New Bern area in this, and we thought it would be great to have Jeff come and spend some time talking about those issues as we can continue to serve a more diverse group of older adults. Thank you, Jeff.
Well, thank you, Mark. Again, my name is Jeff Marsacci. I'm a life and estate planning attorney, and what a lot of my clients say is my biggest asset is I didn't lose the ability to speak in plain English when I got out of law school. And I very intentionally don't talk to a lot of other attorneys because I see that they turn into what I call code talkers. According to section, blah, 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 law and statute, whatever, suddenly they're talking that way to their clients. Their clients have no idea what they're doing, and they say, well, just write him a check. He seems to know what he's talking about. And that's not really right, especially when it comes to what I consider a preventative area, like estate planning, where you're trying to avoid problems before they start. Now, I did plan on talking a lot about the LGBT community and some of the unique needs that are there, but I thought it would be good to just kind of do a little bit of a general overview of some of these general estate planning areas. And in particular, there are a lot of myths that are out there. And I found 5 big myths, and I kind of turned that into 5 ways to really screw up your estate. And I see it all the time. First, and I hear this all the time, we don't need to do anything, we're married, it's all covered. It's not true. It's not true at all. Now, I've seen, in particular for the LGBT community, this is a huge issue. I had some clients that came in, it was about a year ago, and the only reason they came in was because their friend insisted that they come and see me. They demanded it, they wouldn't let it go. And they came in and said, look, we're gonna be all set, but I know this appointment's free, and our friend wouldn't let us get away with going out and getting married before we talk to you. Okay, so what are you planning on doing? Oh, we're gonna go to Massachusetts and we're gonna get married and everything is just fine. Well, I said, well, why do you think that's fine? Because then we're married. And if we're married, we inherit everything from each other. We make decisions for each other. That's the way it is, isn't it? Well, no, it's not. In Massachusetts, if you live in Massachusetts and you're a same-sex couple and you get married, then sure. So I asked them, are you planning to just move to Massachusetts? Well, no, we're coming back here. Well, North Carolina does not recognize that marriage. But we're legally married. No, it doesn't matter. It doesn't matter. That marriage does not have to be recognized in North Carolina, and it currently isn't. And it could be a long, long time before it is. But then I explained, even if you were married, a marriage certificate isn't really an estate plan. A marriage certificate, in terms of inheritance, this really freaks my clients out when they come in. So just because you're married, if that's your only estate plan, that's the only thing you do is you get married. Okay, if one of you dies, how many kids do you have? Oh, we've got 1 kid. All right, your child gets half. What? That's what the law says, they get half. Or if it's 2 or more kids, they're dividing up about 2/3 of the estate. Well, that's crazy, that's not what we want. Well, that's why it's important to do that planning. You've got to have a comprehensive plan, you've got to put it in writing, because things don't just magically happen. And that's really the second thing that I see when people say, oh, it's covered. They say, my family knows what I want. Well, do you know what your family wants? You know, if you don't set things up the right way, it doesn't happen. And if you think, oh, well, it will all just kind of happen and they know what's right, they know what's fair. Well, do you know what your kids want? Because they're alive. You're not here to say, no, that's not what I want. And suddenly everybody's memory is a little bit different. Well, I know that Dad wanted me to have that car. No, he didn't. Dad wanted me to have it. And you know what? It doesn't really matter, because there's a state law that governs what happens to your stuff if you die without a legal estate plan. And it doesn't happen. And I always love this. I usually see it with my clients who come in who are either in their late 80s or early 90s, and they say, I'm just gonna put masking tape with people's names on stuff. And they'll know that that belongs to them. Well, if you're the second child to get into the house, you notice the first child that gets in, suddenly they're getting the plasma screen TV, they're getting the expensive refrigerator, they're getting, you know, the big bedroom set, and you've got a salad bowl. Tape gets moved. It's not an estate plan. So the first way to really screw up your estate, do nothing because you think it's covered. All right, second, I hear this all the time. Joint property with the right of survivorship. Oh, it's great, it's wonderful, it's the best thing since sliced bread. And, well, it can be for a husband and a wife. And that really does lure some people into a false sense of security. And I see this mistake more and more with widows and widowers. It was so easy when my spouse passed on with this joint property with the right of survivorship. I'm just going to go and put the kids' names on everything. And then suddenly you have a whole mess of other potential problems. How many people here are familiar with something called the gift tax? Okay. You might have heard, oh, you can give $10,000, $12,000. We're up to $13,000. It might get to $14,000 next year. We'll see. But you can give that much to an individual, actually to as many individuals as you want, without having to file federal gift tax forms. But if you put your son on the title to your house, you've given your son half your house. In the 16 years when people say, oh, I just put my kids' names on everything, I say, oh, did you fill out your gift tax forms? Not once in 16 years has somebody said, yeah, we took care of that, it's all set. Not once. They'd say, huh? What are you talking about? That's an issue. That's a big issue. And it's, in particular, it's a big issue for domestic partners as well. And I'll talk more about how the gift tax in planning becomes a particular problem for LGBT couples. All right, so gift tax forms. Second thing in joint property, once it's transferred, you've got to get your kids' permission to get it back. Well, what if you put your 2 kids on the deed to your house, and you decide, you know what, I want to sell it, I want to downsize, I want to move here? Well, if one of your kids doesn't want to sell, you've got a problem, because they're an owner. And suddenly, this thing that you were trying to do for estate planning convenience has become a much bigger issue. I had a client, he wanted to move his stock account. He had his 3 kids as co-owners on his stock account because he wanted them to inherit it without probate. I know we're in the administrative office of the courts and they handle all the forms for probate, so I won't speak too loudly about that. He wanted it to avoid probate, but Dad said, you know what, my stocks just haven't been doing too well. This advisor just isn't really any good, and I need to move it. Problem was that financial advisor was his son-in-law, and he had to convince his daughter to basically fire her husband so that they could move his stuff. So you can bet that was a nice Thanksgiving dinner the next time around. Third downside for joint property. If a child gets sued, suddenly it's your problem. I go to a lot of different national conferences and talk with a lot of different attorneys and other financial advisors. And one story, I still tell it every chance I get. There was an attorney down in Florida, and a woman came to him and said, look, I want you to put my daughter on the deed to my condo. And he said, being a good attorney, well, why do you want to do that? Well, I wanted to be able to inherit my house without probate. I just want it to be nice and easy. And he said, well, look, there are some downsides to that. There's the potential for lawsuits, there's gift tax forms, there's all this other stuff. Let me talk to you about a revocable living trust. This is what it is, this is what it does. That's too complicated, I don't want to do that. She went to a second attorney. Same thing, put my daughter on the deed to my condo. Well, why do you want to do that? Well, I want her to inherit it without probate. Well, let me tell you about a revocable trust. No, that's too complicated, I don't want to do that. She goes to a third attorney. You kind of get where we're going here. She doesn't want the right answer. She wants the answer that she wants to hear, which is, oh, sure, I'll go ahead and do that. And she eventually went to what I assume was just a real estate attorney who didn't do anything with estate planning and didn't understand this and said, oh, sure, why not? The daughter did get into a car accident a little more than a year later. It was entirely her fault. There was a big lawsuit, a big judgment. The daughter declared bankruptcy. And under Florida law, the daughter got to keep her house. But that extra real estate that she owned with her mom, sheriffs came, sold that condo at auction, gave mom a check for half the proceeds, which really wasn't all that much. And suddenly mom has to move in with her daughter because she doesn't have anywhere to live. It's not the typical thing that happens, but it can happen. So why take those kind of risks? And then the last one, I have to tell the story because it's bizarre and it's frightening, but it does happen every now and then. I was talking about joint property with the right of survivorship with a group of bankers in Nightdale and some of the downsides and the risks, and they said, oh gosh, I just wish you were here like 3 weeks ago. Because just last Friday, one of our longtime clients came in and she was screaming. Right, now this is exactly what the manager said, it's not my characterization. She said, I have never seen an 80-year-old woman so tiny scream so loud. I'm gonna sue you, I'm gonna have you all arrested, I'm gonna own this bank, how dare you? The manager came over and tried to say, well, what's going on? What's the matter? You let my son take all my money. Well, she said, let me sit down, check the records, and they saw that there were changes made on the account a couple of weeks ago. And what had happened was the woman came in with her son and said, I want you to put my son on all of my accounts as joint with a right of survivorship. And the representative said, well, you know, ma'am, we've got a couple of different options. And, no, joint with a right of survivorship. Okay, you're the boss. Filled out the paperwork, signed it. Son went in about a week later, took all of her money, and disappeared. Gone. Her whole life savings disappeared. And they said, well, ma'am, you put him on your account, you gave him that authority. You empowered him to take all your money out. You know what she said? Well, that's not what I meant. What I meant was I wanted him to inherit it without probate and be able to get control of it if I got sick. Well, the thing is, if the police ever catch up to him, he didn't do anything illegal. She gave him permission to do that. And so he disappeared. So I've spent a little more time on this than some of the other areas just because I hear it all the time. Oh, we'll just do joint property with the right of survivorship. That's like doing car repairs with duct tape. Maybe it looks like you're getting away with it for a little bit, but when your engine drops out in the middle of the highway, it's not very good. All right, third downside, third way to really screw up your estate, beneficiary designations. Now, this has a place in estate planning, but it's not the only thing because there are no really big contingencies that are put into this. Someone's a beneficiary on a life insurance policy. Someone's a beneficiary on a retirement account. Well, I hear this all the time. Oh, I'm just going to name my 3 kids as my beneficiaries. All right, what if one of them passes on? What do you want to have happen with those assets? Because it does happen. Children sometimes die before their parents do. What do you want to have happen? Oh, well, in that case, I want that third to go down to the grandchildren. All right, well, that's not very explicit in the beneficiary designations. You might be able to get it. What age do you want those grandkids to actually be able to control the money and spend it as opposed to someone else spending it for them and helping them make the right decisions? oh, well, I want 30's kind of become the standard age now. It's drifted from 21 to 25, and a lot more of my clients are saying 30's the age where you want to give them control. You can't do that on beneficiary designations. You can't. And this is a very important distinction because I hear it all the time. My will says they don't get anything till 30. Well, a beneficiary designation bypasses probate, which for a lot of people that's an admirable end. That's what they want to do. But because you've avoided probate, your will saying they don't get anything till 30 means absolutely nothing. I had a financial advisor who was trying to get his clients to come to me for many years, and as a stopgap measure, they put their 17-year-old daughter as beneficiary on about $700,000 worth of stocks and investments. And just a few weeks shy of her 18th birthday, they both died in a car accident. And suddenly their daughter turns 18, gets all this money. Within a few months, she's married to some 25-year-old that she met while partying. She bought a big house she's never going to be able to afford to keep up on the taxes. She's decided, well, I've got about $120,000 of it left. I don't need to go to college. That money's by now gone. Just gone. With a little bit of maturity, with someone to help and to have guidance over that as a trustee, it probably would have been a lot different, but that's not the way it happened. And there's no protection for the beneficiaries for disability, Medicaid, or lawsuits, which can be an issue. We will talk a little bit about special needs estate planning. Fourth thing, I'll just use a will instead of a trust. How many people here think that the will is the way you divide your property, the optimal way, even after hearing me talk? Okay. A will takes care of assets that end up in the probate court system. A lot of my clients want to avoid that court process if they can. It makes things go much more smoothly, much more quickly, if it avoids the court process. Just in general, what I've seen and what some national studies are, and this does vary depending on estates. Honestly, it depends on what the clerks of court are like in any particular county. It can be a lot different. It's about 4 to 10% of an estate gets eaten up by administrative costs, mainly attorney fees. If you get an attorney to handle things, it's gonna cost. And when you say 4 to 10%, for a lot of people, you're gonna take 4 to 10% of my assets, that's crazy. But when you tell the beneficiaries, well, you're gonna get 95% of it, the rest of it's costs. Oh yeah, go ahead, just take care of it. That's not the way my clients want things to happen, but sometimes it does. You know, I had, actually, it was another financial advisor from Florida was telling me he was out playing golf with 3 trust and estate attorneys. It sounds like a joke, it's a real story. He was playing golf with 3 trust and estate attorneys, and they started talking about retirement planning. In fact, the financial advisor got them on retirement planning because he wanted to know, is there anything I can do to help you with your retirement planning and handle your investments? And they said, I got my retirement planning all set. I got 58. 58 what? And the second guy, I got you beat, 72. 72,000. That's for a trust and estate attorney to brag about that. That's not a lot. 72 million. Why isn't he just playing golf all the time? What's he talking about? And the last guy, the old one, says, I got you both beat. I got number 126 this morning. And he finally said, what are you talking about? Retirement plan? What are those numbers? Oh, that's how many wills we have in our files. Their retirement plan was the money they were going to make off their dead clients' estates. And they were very brazenly talking about this. I mean, it's crazy, but there's an entire probate industry built around this, and it's to the detriment of clients. Now, I prefer to sleep at night, so I let my clients look at all the options, and if they still want to do a will, all right, that's fine. If they want to avoid probate, there are ways to do it. A trust is one of them. Delays are typically 6 months to a year and a half. Will contests. This is actually a much bigger issue with the LGBT community because there's still a stigma of being part of the LGBT community. And a lot of family members will simply say, well, that's not right, I don't want that going to the partner, let's contest things. Well, if it's contesting a will, if it's in probate, then suddenly there's a whole system designed around resolving those disputes where most of the time, all the attorneys are gonna get paid out of the estate probably. That's just the way it is. And so if someone comes to me and says, I wanna contest a will, if I had even the smallest thing to kind of hang my hat on, I'm probably gonna get paid, so I can do it, no money up front. Somebody comes to me and says, I need you to contest this revocable trust. Okay, now suddenly that's outside of that probate court process. There's gonna have to be a really big showing that it was in fact wrong in order for me to get paid from the other party. And so I gotta say, well look, I can look into that for you. I need about $10,000, $15,000 as a retainer. Suddenly, it's an issue. Because people who want something they're not entitled to aren't really willing to put up their own money in order to try to get it. So, having a good trust will lower that risk that there either will be a suit and contest, and certainly that it will be a lot less likely that they'll get through and win at the end. And then the fourth big downside for probate, which is using a will rather than a trust, it's a loss of privacy from the estate. Have you seen any probate files? I don't know if you do that as part of what you do, or has anybody seen a probate file? So has anybody been an executor or an administrator for an estate? Okay, so you've seen the forms and what needs to be filled out. You have to list every bank account, every stock account, every piece of real estate. You have to list the date of death, totals, and values for all of that stuff. You've got to list all the money coming in, all the money going out, the names, ages, and addresses of the beneficiaries, and it's a public document. So anyone can go in and look at that stuff. And I had a client, it's been several years, he called me on a Friday and he said, Jeff, I have a Friday afternoon question for you. That was his way of saying, I'm only gonna ask it if you don't bill me. I said, all right, fine, it's Friday afternoon, what's your question? He said, my dad died in Michigan about 4 months ago. Does that have anything to do with the fact I'm getting all of these brochures from Mercedes and BMW? And I said, yeah. They probably got that information through the court system. They know you're gonna get a bunch of money eventually, and they wanna be first in line to help you spend it. Isn't that nice of them? But the information's all out there. Marketing people do go through estate files and see who has money. That's just the reality of it. All right, and the fifth way to really screw up your estate is using the wrong attorney. There are a lot of attorneys out there that I call also attorneys. You know, they do a really good job and they do an awful lot of real estate, and they say, oh, well, I suppose I could also do a will. Or they've got a big divorce and child custody practice, and yeah, I suppose I could do some powers of attorney. But by and large, they don't understand a lot of the intricacies in certain situations, particularly when it comes to LGBT couples. And a lot of times the attorneys are also just pushing wills because that's what they've always been taught. One of the reasons I got into this field was I saw what my grandmother had to go through when my grandfather died, and having to deal with probate court up in Rhode Island, and all the mess that went around just because the house was titled incorrectly and had to go through the court process. It destroyed her. She felt horrible for a year and a half. She said, I've just got this uneasy feeling in the pit of my stomach that my house isn't really my house. Nobody should have to go through that. And so that's why I looked into this field to begin with. And probate is about a $50 billion a year industry now. That's an awful lot of money, and most of it's going to attorneys. It doesn't have to happen that way. And actually just recently, there was an attorney who I looked him up after. He was from one of the large three-name firms, Dewey, Cheatham, and Howe. Well, that's the Three Stooges. And he had this doesn't mean anything, but he had a kind of distinguished name like Thurston Howell III. And from what I found out from the family, he charged a lot of money to do a will. And the thing that made it, quote, complicated was the client had 4 kids, but one of his daughters had already passed on, and he wanted to leave her 25% share to her 2 sons, and wanted it held up in trust so that the other daughter, the aunt, could administer it for him until they turned 30. Okay, so that was fine, except the aunt didn't want to do it. And they didn't leave any other instructions on who the trustee would be if the daughter said she didn't want to do it. So I said, well, look, you have to go to court and get the court appoint someone as an attorney, as the next trustee, or just do it. Just do it for the kids. And she decided it wasn't worth the trouble, so she just said, okay, I'll do it. But to not have any contingencies like that, doesn't matter how much you spend or the reputation of the firm, it's really whether they know estate planning. All right, so what are the 5 documents that are needed? I'm not going to go too deeply into it because you've all gotten this book, The Anti-Probate Revolution. And really, the 5 main documents, the Revocable Living Trust, it's something everybody should take a look at. Doesn't necessarily fit for all situations, but it fits for a lot more situations than a lot of attorneys will let on. Second, you need to have a financial power of attorney. Now, there are dozens of different names. There's a durable general power of attorney, springing power of attorney, leaping frog power of attorney. It doesn't matter. It all comes down to what does the power of attorney do? If it's handling finances or dealing with government agencies and handling tax, that's the financial power of attorney. As opposed to the third document, a healthcare power of attorney, where you're having somebody handle these things for you. Now, I always recommend name individuals as your agents. Don't name your 3 kids. That's just a recipe for arguments. I can't think of 3 kids who can agree on what to order on a pizza, let alone something in the middle of a healthcare crisis. So just put them in some sort of order. So you've got one person, if they can't do it, there's a backup. If they can't do it, there's another one. And as we'll talk about in a minute, this is a particularly vital document for LGBT couples to have, the healthcare power of attorney. 4th document is what we call a pour-over will. It's just a last will and testament that says if anything does end up in probate, send it over to the revocable trust and the trust takes care of it. That actually helps streamline probate because there's only one beneficiary, the trust. And if everything's done properly, most of the major assets, if not all of them, have already been either signed over to the trust or they're avoiding probate some other way. So it's kind of just a cleanup mechanism.
What's it called again?
A pour-over will.
Pour over?
Yes, like you're pouring something over. It's just a last will and testament where the trust is the beneficiary. Now, I had a client, this is going back many years. She had 2 savings accounts that she told me about. We moved those over into her trust, so it was going to avoid probate. And then when she passed on, called up the bank, and I said, well, we just need you to write a check out, close out those accounts, write a check out to the revocable trust, and the niece is going to take over as the trustee. And they said, which 2 out of the 3 accounts do you mean? I said, what are you talking about? Apparently she had a $6,000 savings account that she lost track of and hadn't had statements on in many years. All right, that $6,000 had to go through probate. We did that. This past summer, I had a client, she forgot one checking account. Everything else was handled by her trust. That checking account had $212. I said, tell the bank they can keep it, it's not worth it. Okay, that was fine. Right, and then the 5th document, which is, I guess, kind of optional. It's called a living will, a declaration of a desire for a natural death. That's if you want to put your wishes regarding life support, nutrition, and hydration in writing ahead of time. If you don't have the living will, and you do have a good, well-drafted healthcare power of attorney, it kind of falls on your healthcare agent to make that decision. So that's the way some of my clients want it. Other clients say that's just too big of an emotional burden for me to put on them. So let me do the living will and put in place what I want. Okay. Now, getting specifically to issues with planning for LGBT clients, I've found there are 3 main goals that are prevalent for most couples, but every couple's different. Everybody has different things that they want. It's my job to see whatever I can do to help them get it. First, they want to kind of bring everything together as one family unit. And there are ways to do that if you do it the right way. The gift tax is something that kind of gets in the way a little bit, but we can do it. Second, they want to empower each other to make decisions in the event of a crisis. And so if they get sick, it's their partner that they want driving things, not the next of kin, the closest family members who will just come in and do what they want. And the third is inheritance. They want to make sure that they have the right kind of inheritance for their partner. In some cases, it's, I want my partner to get everything, and they can do what they want with it. Other cases, it's, I want my assets available if my partner needs it. And if they don't, then I'm going to want it to go to this set of beneficiaries after my partner's gone. And in either case, we have the documents that can do it. It's essentially, it's a joint revocable living trust. They put their assets jointly into this trust. But we also have something called a domestic partnership property agreement that just kind of spells out whose assets are really in the trust and who in the end has control over it. Now we do that for a couple of reasons. First, there's a 50% divorce rate in the heterosexual community. It's no different for couples that are LGBT. And so this agreement will just split things up the way they went in. And so it kind of acts like a premarital agreement. That's not something we highlight, but it's still there and it's still kind of important. The other thing is the gift tax. If they just put their partner's name on all their assets, then each partner is gifting half of everything to the other. That's no different if they just dumped everything into the trust without that property agreement. So what we want is we want to avoid probate. We want to make sure that their plans are in place, but we don't want to trip up the gift tax while we do it. If you want to know more about the mechanics of that, you've got a book for that, Estate Planning for Domestic Partners. And I'm available for questions on that too. And now, just another thing, a fourth thing, people want to avoid taxes as much as possible. It's no different for the LGBT community, but the problem might be a little more pronounced than with married couples. In federal estate tax law, married couples get something that's called the unlimited marital deduction. Means it doesn't matter if they've got 2 million, 4 million, 40 million. The surviving spouse is never going to have to pay estate taxes. It's what happens when the second person passes on. Well, I'll go to the board for this one. Let's just say we have a couple, John and Jim. John has $1 million. Jim has $1 million. All right, what happens if they put together an estate plan and Jim just leaves everything to John? If we go back to the tax rules for 2013, and please don't have me explain the whole tax rules thing. I could spend 25 minutes just on that. The exemption in 2013 is supposed to be $1 million per person. Okay? What happens then when John passes on? How much does John have? He's got $2 million. That's taxed at 55%. So that's $550,000. What if instead this were $2 million? Jim would have to pay $550,000 when he passed on. And now John actually has, instead of $2 million, it's 2.5 million at 55%. This money from Jim is being taxed twice. We can't do anything about the first tax, but in the trust that we put together, there's a mechanism so whatever Jim is leaving, you know, it's the 1.5 million that's left over after taxes. John's got his $1 million. When John passes on, 0 taxes, and that's already been paid. So they don't have to pay taxes again on the money that Jim had. Yes?
Is this scenario not true for an unmarried straight couple?
It is exactly the same for an unmarried straight couple. Exactly the same. Either you're married under federal law, it's a federally recognized marriage, or it's not. That's it. All right. Is there another question?
Is there a North Carolina law regarding probate? If you have to act out your assets are less than $80 million?
It's been so long. It's usually Dina in my office handles small estates, but it's only something like 20,000, somewhere in that neighborhood.
So there is a number.
But it's 20,000. It still quote goes through probate, but it's a much more expedited process where you're basically signing some affidavits and it's done. But anything above that, it's suddenly you've got to do the whole long process. Yes.
I'm in the western part of the state. One thing I'm running into is, and I don't know all the legal terms, this is just what people say to me, is that their parents, and lots of times, you know, a lot of people are cash poor, but acre rich, so to speak.
Yeah.
And what they will do is the parents will leave their house and all their property several years before they go into nursing home. That's their plan.
Yeah.
To their children. So.
Okay.
What are the ramifications of that? Does it depend if they did a will or a trust, is what you're saying?
Well, if they gave it to their kids
I
ahead of
think they put it in
time,
their name.
that's a gift. They gave it to them.
Did they buy it from
So
them?
that they put it in their name, so I guess it's a gift then.
It's a gift, right? So they should be filling out gift tax forms. I'm not sure if that happens as often as it should.
Yeah.
If it was large enough, they pay whatever gift tax there was. Now, what are the consequences? If they need nursing home care within that 5-year period, it's gonna be an issue because it was a gift within the past 5 years. The other issue, which not a lot of people think about, is what happens when the kids turn around and sell it, if that's what they're gonna do. Now, if you've got like a family farm and it's a big entity and they're gonna just keep that going, well then that's not an issue. But I had a client's kids, actually it was the kids, an accountant sent them over to me because they refused to believe the accountant. Apparently mom had put the kids' names on everything about 7 or 8 years before she passed on. Actually, no, it wasn't even that long. She just put the kids' names on everything, so it was owned by 4 people. And when mom passed on, she told them, look, I just want you to sell everything and divide everything 3 ways. And so that's what they did, including the house that mom had lived in for 35 years, including the stock that she had hung on to from working at IBM all those years ago. And so her tax basis was kind of small. Let me go ahead and write this out. Let me just try to figure out numbers here. I think it was about $800,000 fair market value of everything. And so fair market value was $200,000 for each child and mom. Okay, what was the tax basis? In other words, what did mom buy it at? Well, it was about, let's see, $50,000 each. Right. When somebody passes on, whatever they own, the tax basis gets bumped up to fair market value. That's the way the estate tax law is written. If we're going to look at it for estate taxes, then we're going to bump it up to fair market value. Right, well, what happened here? Only mom's tax basis got bumped up to $200,000. So that's what? $450,000 of gain when the kids sold the assets. Capital gains taxes. And some of it was, and I believe some of this was also, no, it was mainly stock and real estate. And so $450,000 subject to capital gains taxes, that was an awful lot of money. And the kids had no idea they had done it until they went to the accountant. That's why they didn't believe the accountant. Mom had less than $1 million. There are no death taxes. Well, yeah, but there are capital gains taxes. Mom had put it in a revocable trust. She still would have avoided probate, which is what she wanted to do. But her kids wouldn't have had all of those capital gains taxes to pay at the same time. So, unfortunately, there was nothing that we could do there.
So in the revocable trust, then, there would have been no taxes on that.
Right, because it still would have been as if Mom had owned everything. So there's that capital gains tax problem. All right, on the other end, if the big issue is Medicaid planning, then okay, you've got to balance that against what the kids are going to have to pay in capital gains taxes afterwards, because there isn't going to be a bump up in the fair market value of the assets when the kids sell it after Mom dies. All right, I want to make sure that I at least. Okay, special needs estate planning. How many people come across clients with kids who are special needs? Or okay, so there is an issue there. This is one of the simplest areas to actually plan for, but attorneys make it sound it's like the most complicated thing in the world. What's complicated is applying for the benefits in the first place and getting everything in order and making sure that the benefit, the person receiving the benefits is under the asset limits and under the income limits. So planning for an inheritance to that child really isn't that complicated. You just don't leave anything to a special needs beneficiary. In my other book, The Simple Guide to Special Needs Estate Planning, basically there are 3 rules regarding direct inheritances for beneficiaries. Rule 1, never leave anything directly to a special needs beneficiary. Rule 2, never leave anything directly to a special needs beneficiary. And Rule 3, never leave anything directly to a special needs beneficiary. You just don't do it. And this is an area where attorneys mess up all the time because they're trying to be clever. And I saw, unfortunately had to counsel them, the attorney drafted a will, which, okay, even with the special needs provision and the drawn out probate, whatever, it ended up getting into the right place, but they left the house directly to the special needs beneficiary. Because at the time, they could leave any house to a special needs beneficiary and it wasn't going to mess up their benefits. Well, what happened? The rules changed, and now suddenly there's an equity limit in the house. And so the uncle who was in charge of the trust for the special needs beneficiary is being told by the attorney, what you need to do is take $170,000 out as a line of credit and spend the money and then reapply for benefits. Why? Well, it's because the attorney messed up. If all the attorney had done was left the house to the special needs trust that he created anyway for everything else, it wouldn't have been an issue. But he was trying to show off that, well, I know that they can get the house and I know that they can get the vehicle, and that was actually another issue. The child had already bought their own vehicle, and so they got another car. What they have to do is sell the car. Well, you just don't ever leave anything directly to a special needs beneficiary. You leave it in trust, and you have the trustee in charge of it, so that they can work within whatever the rules are. If you think about it like this, I'm sure there are plenty of attorneys that do DUIs out there. And you can ask them, well, how many drinks can I have if I plan on driving? What kind of breathalyzers are out there for me to test so I can check and see whether I've had too much to drink? And what if I go in and I drink 5 drinks in the first hour, but I have a full meal? How many hours before I can drink? You know what? Don't drink and then drive. And if you're gonna drive, don't drink. That's it, nice and simple. All of those other complicated rules and all the other stuff, it doesn't mean anything. You don't have to deal with it if you just follow that rule. Okay. Another thing with special needs planning, if you have the right kind of revocable living trust, you don't really need to put together a separate special needs trust for a beneficiary. All of those provisions can just be incorporated into the revocable living trust, and for all the trusts that we do, they are. The only time you need to do a separate special needs trust is if someone other than the parents are going to leave money for the special needs beneficiary. In other words, grandparents want to. Well, then that money needs to go somewhere, and presumably, if life takes the course we expect it to, the grandparents are going to go before the parents go. And so if the grandparents want to leave money directly to the grandchild, it should be in a separate special needs trust. And there's also a way to structure life insurance in an existing separate irrevocable special needs trust so that the life insurance becomes estate tax free as well. It can leave a significant amount of assets to that beneficiary. And again, that's also in here. You've got my contact information. If you need to know more about that, just let me know and we can send you more stuff. All right. That's really all that I had specifically, but I do want to open it up for questions. There really is no doubt that LGBT couples need a little bit more, or they need more specific type of planning to get what they want. But what a lot of people don't realize is that those mechanisms are out there, and they are available, and they can be used. Yes?
When it said that you set up a revocable living trust, but you don't have to fund it yet, what would an attorney be? I mean, what would they mean by that?
That would mean, don't worry about funding it. Your pour-over will take care of it, and by the way, I'll get the 5% for the probate on the stuff pouring it over to the trust. I wish I could say it was different, but there are attorneys out there that want to make their living off the probate process. And if a client comes to them and they say, I want a revocable trust, I read about it, this is exactly what I want. Oh, okay, fine. They set up the trust, and then they don't help them or advise them to put anything in the trust, so it still goes through probate before it goes to the trust. They've actually effectively added another layer of bureaucracy that they're going to get paid to help administer. There's just no reason to leave a revocable living trust unfunded. And one asset in particular that I hear all the time, and attorneys are actually pretty snotty when they talk to me about it. Oh, you never put the primary residence into the revocable trust. Well, why? Well, because then it's like lawsuit protection. Because if a property is owned as tenants by the entirety, which is really joint with the right of survivorship for married couples, then it's immune from lawsuits. What are the chances that somebody is going to be sued to the point that they're going to lose their house? Now compare that to the odds of somebody dying at some point. Everybody's going to go at some point. Now, if protecting the house is that much of an issue because they are in a high lawsuit-rich profession. OBGYNs. Stuff happens when they're delivering babies, and it could cost an awful lot to help that child. They could lose everything. All right, extra protection is needed for them to set things up so that they don't lose the house. But just saying, oh, just do tenancy by the entirety, no, that's not the right way to handle it. Yes?
Could you speak a little bit more to how the revocable living trust works? Do you designate someone to manage it, or?
Okay.
I don't quite understand how that works.
Yeah, it's kind of like bylaws for a corporation. It's not like some tangible thing. You get a document, but it says, here's how things are run. You need to have things set up so you've got a trustee, and usually for an individual or a couple, they're the first trustees. They keep control over it. And then they list who are the successor trustees, who takes over when they die or if they get too sick to handle it themselves. And then everything that you expect to find in a will, and then some, is in there. Who's getting what, at what age? What are some of the conditions? How is that handled? Now, here's the real secret for why a revocable trust avoids probate. Probate only grabs a hold of something that is still legally in a deceased person's name. And then the process is to retitle it. So if it's titled in the name of the trust, then it doesn't have to go through probate. So if you really break it down, all probate is a big, elaborate, expensive, and frustrating retitling process for estate assets. And if you can avoid it, a lot of my clients prefer to. And it's by titling those assets in the name of the trust that helps it avoid the court process. Because it's not in a deceased person's name anymore, it's titled in the trust. And even though they still keep 100% control over their own assets as the trustees, probate isn't concerned with control, it's concerned with title. Yes?
If property was put in a trust to children's names, and that was years ago, at the time of death, would there still be the gift tax in place, or how does that, I mean, gift paperwork have to be done?
Okay, let's just, it was an irrevocable trust, and mom and dad moved stuff into the trust, and the trust was now controlled and owned by the 3 kids.
Yeah.
Is that what we're talking about? The gift taxes should have been filled out at the time that the money went into the trust when it was controlled by the kids. If they didn't, if it was more than 7 years ago, that's kind of the look-back period for most of the IRS stuff. All right. Although I do have to warn people that in an estate audit, they can go back as far as they want to look at everything. So it could still be an issue. Did you have a question?
Difference between revocable and irrevocable, and if you give a roundabout cost to do those things.
Okay.
And I know that would be.
I'm going to answer only one of your 2 questions, but I'll tell you why on the
Okay.
second one. Revocable means you control it, it's yours, you can do what you want with it, you can amend it at any point, and it's because you want to avoid probate. You want to have someone in control if you get sick without having to go through a court process to appoint someone. Irrevocable, most of the time that's for asset protection, Medicaid spend down, or you just want to gift it out of your taxable estate. And that's giving up control. It's done, it's out of your control. And there are a lot of people looking at that as a potential issue because when we go back to $1 million per person for estate taxes, suddenly they have a lot more that would be subject to estate taxes. Right now it's $5 million a person until January 1. So not a lot of my clients have an estate tax issue now. They do. All right, the reason for the second question, why I'm not going to answer it, is I never answer it, because some people say they have an extraordinarily simple situation and it's anything but. And then I have people who say, oh, it's so complicated, but they're saying it's complicated because they have a lot of assets. What they want to have happen actually could be pretty easy for me to do. What takes a lot of time and why I don't quote is because I've had people say, I've got a very simple estate. Now, I've got 15% that's going to this nephew. But if the nephew is still dating that person, or they're married to this person they brought to Thanksgiving dinner, it's only going to be 8%. I want the other 7% divided in half, so it's 3.5% to this niece and 3.5% to this person. But if this person is still going to that church, then I'm not going to give that to them. I want the 3.5% divided. Oh God. Okay, so it's all over the place. Their mind, it's simple, but it's not. So what I tell people is, look, if you want to look at this, you want to sit down and go through stuff, all right, we can send you a pre-appointment packet. It's got some basic outlines, and your first appointment is free. If you come in and the packet's still unopened and you haven't read any of the stuff I sent you, your first appointment's $250, your second appointment's free. All right. And that's because I have to spend the whole first appointment regurgitating everything that was in the packet that goes through stuff. Right. I see we're at 4 o'clock. How are we? Do we have time for more questions?
Do we have just one more? Anybody else have a question? Well, let's show Jeff how much we appreciate the information. Do you have his contact information?